Employers Assistance pre-recorded webinar series. In this webinar, we will be discussing minimum employment standards at a high level, including general employment law obligations in relation to New Zealand's employment law framework and Holidays Act issues. My name is Ken Duffy, lead solicitor and senior employment lawyer here at Employers Assistance. In terms of an agenda for today's discussions, we'll be looking principally at New Zealand employment law and Holidays Act issues, from minimum wage obligations and the increases coming in April 2025 to overtime pay and arrangements, public holidays, and tricky issues regarding leave calculations and payments under the Holidays Act 2003, including some information at the back end around casual employees and some of the common pitfalls or issues when employers engage these sorts or categories of workers. In terms of New Zealand employment law, at a very high level, most business owners and employers have a clear understanding that it is generally heavily geared towards employee rights and conversely stacked against employers. It is the obligation of employers at a general level to comply with various legal obligations and legislation. So there are a range of acts or statutes by government that employers must adhere to that are relevant to the workplace and employing staff. So these include the Employment Relations Act 2000, the Health and Safety at Work Act 2015, the Holidays Act 2003, the Privacy Act 2020, the Parental Leave and Employment Protection Act 1987, the Minimum Wage Act 1983, and so on. There is also obligations arising or stemming from case law, so cases and legal principles that get distilled from the Employment Court and sometimes guidance from the Employment Relations Authority in some cases too, which is very useful in terms of informing how employers are to apply the law in certain areas where sometimes there's ambiguity. The key point in terms of the statutory regimes and the legislation is that ignorance of the law is no excuse. Employers must comply, and if they fail to comply, then there can be consequences for that. Seek advice for employers' assistance if required, and we're only a phone call away, 0800 15 8000. In terms of minimum employment standards, this effectively informs the baseline that employers must comply with. So you can always go above minimum employment standards by way of enhanced entitlements, whether that's in terms of pay or holidays, holiday benefits and arrangements, perhaps 5 weeks annual leave rather than 4, but you can never go below whatever the applicable standards are. So you cannot contract out of minimum legal standards by way of an employment agreement with, say, an unlawful contractual arrangement that seeks to water down or reduce or otherwise abrogate minimum code entitlements. There are some fairly serious consequences for non-compliance, particularly where the non-compliance is deliberate and has been engineered in a way to effectively reduce employees' legal entitlements. So this can result in things like arrears claims, so back pay or penalties claims, so penalties being awarded for particular breaches in certain circumstances, labour inspectorate investigations and litigation processes around those, stand down orders which prevent employers from hiring people on visas or migrant workers, banning orders in really serious cases where directors can face being prevented from being involved in hiring or employing staff. There are also brand and reputational considerations that may be at play where cases go public and the employer may have flouted minimum code legal entitlements, not paid staff minimum wage or whatever it is, then that can reflect badly on an employer's brand. Minimum code legal entitlements at a high level include things like minimum wage, annual leave, holiday pay, public holidays, sick leave, family violence leave, breaks, parental leave. These sorts of things are all covered by the general umbrella of what's meant by minimum standards. So it's important to have a good understanding of what key minimum entitlements are and to comply with those entitlements as an employer. Having a legally compliant employment agreement, whether that be a permanent, fixed term, or casual employment agreement or contract, is a very good starting point. And employers' assistance. We have the employment agreement builder and guidance commentary to help you customize and generate or build a legally compliant employment agreement, which can be accessed as part of our subscription or otherwise located on the product section of our website. In terms of minimum wage obligations, employers must comply with this when hiring and paying staff or employees in New Zealand. It is an absolute baseline and you cannot go below this. So the adult minimum wage applies to all employees who are 16 years or older, provided the exemptions in the slide about starting out minimum wage or training wage don't apply. So it's currently $23.15 per hour, the adult minimum wage, but that's set to go up in April, on the 1st of April 2025 this year to $23.50. And also the applicable starting out and training wage will increase by a similar margin. There's information on the slides there regarding the increases. Overtime pay or pay for overtime. There is no statutory overtime or rates in New Zealand employment law, except for any hours worked on a public holiday, which is typically described as penal rates. So if an employee works on a public holiday or any part of a public holiday, they must be paid at least time and a half for all hours worked, and that's written in law in the Holidays Act. Outside of that, there is no statutory obligation to pay an increased overtime rate. So overtime is a contractual entitlement, and it's usually incentivized to usually used to incentivize wage employees to work additional hours over and above their minimum hours. For example, time and a half after say 40 or 45 hours each week, is usually what employers will consider. An employer can also offer just simply the usual wage rate for any additional overtime performed if they wish, but that's not much of an incentive to get an employee to agree to work beyond their minimum hours. That leads to the last point regarding employee availability and the law on availability, which is a separate area. But an employer cannot require a waged employee to perform overtime or work in addition to their minimum guaranteed hours. So once the employee has worked their guaranteed hours, so for example, if that was 40 hours a week, Monday to Friday, and they finished that, but the employer was particularly busy on Saturday and Sunday, the employer could not require the employee to work additional hours. The employee must agree to that because of the law on availability. That is a topic for another conversation, but it's the short point to note. So to get around the availability law, often employers will simply incentivize waged employees to agree to work additional hours over and above whatever they're contractually specified is. So overtime after 45 hours, say, so there is some leeway or incentive for them to work additional hours. In terms of public holidays, these are again minimum code legal entitlements that arise under the Holidays Act 2003. So there are different section references and numbers that denote where certain key information on the preceding slides are inside the Holidays Act. If you want to check those references out, you can find that on the New Zealand legislation website, so legislation.gov.nz, and find the applicable statute being the Holidays Act. So there are 12 public holidays in New Zealand, and an employer must pay at least time and a half and give an alternative day if that's a normal day of work and an employee works on that public holiday. Those are the rules that is spelt out black and white in the legislation. The entitlements do depend on whether the employee works the public holiday or not, and whether the day is an otherwise working day. So if an employee doesn't work on a public holiday and they have the day off for rest and relaxation, say, or the employer is closed and that day is an otherwise working day, then they still must be paid for that as per their relevant daily pay, is what the law says. Some public holidays are subject to a transfer rule if they fall on the weekends. So public holidays over Christmas and New Year's, Waitangi and Anzac Day, if those public holidays fall on a Saturday or or Sunday, then there are rules in the Holidays Act that they will transfer and be observed on the following Monday or Tuesday if the employee doesn't work on those days where they fall on a weekend. Again, I've explained this earlier, is that if an employee works on a public holiday and that's an otherwise working day for them, and that what that means is a normal day of work, they typically work on the day the public holiday falls, then they must be paid for their time and a half for all hours worked and provided with that alternative holiday. You'll see there that the references in the law are section 50 and 56 of the Holidays Act there. If the employee doesn't work, then they must be paid at least their relevant daily pay or average daily pay if that day is an otherwise working day for them. So the test is the otherwise working day, and that informs entitlements and, of course, whether the employee is working or not in terms of the employer's obligations concerning payment. Employment agreements must also include a provision that confirms an employee's rights to be paid for public holidays, and that's under Section 52 of the legislation, which is essentially the stuff that I'm talking about now that needs to be embedded into the employment agreement. So, both parties are informed effectively on what the entitlements and the law is regarding these sorts of entitlements. Leave calculations and payments. So this can be a really tricky and complex area, or areas rather, under the Holidays Act 2003, and there are a range of problems that can present for employers with this particular area. The calculations and the law at different parts can be quite tricky, and I'll come back to that later. But at a high level, there are different calculations for different entitlements or circumstances. So, for example, if you're paying holiday pay on a pay-as-you-go basis for a genuine casual employee or a fixed-term employee who's employed for a period of less than 12 months, then you have the option to pay 8% holiday pay on top of whatever the employee's typical wage or agreed wage rate is. And the legislative reference here is Section 28. If that doesn't apply and you're dealing with a permanent employee, then they will accrue annual leave entitlement in the ordinary way, and when it crystallizes or reaches its anniversary period and the employee takes that leave, then the employer must do some calculations under the Holidays Act and pick the higher rate when it comes to paying those holidays. So you'll see there that Section 21 is the relevant legislative provision here, and that's the greater of ordinary weekly pay or average weekly earnings that your payroll system should be doing in relation to how staff get paid. I won't go through all of this stuff. We do have an ebook on holidays and leave, which you can check out. But in terms of public holidays, sick leave, bereavement leave, these other sorts of entitlements, you've got the calculations concerning relevant daily pay or average daily pay, and those are slightly different depending on how, which one you decide to use there. Just some general compliance tips in terms of the Holidays Act. So it's important to familiarise as the employer with yourself with the Holidays Act 2003. It can be a tricky piece of legislation, but you need to have a baseline understanding if you're employing staff around what that piece of law stays in the purview of an employee's Holidays Act and associated entitlements. Check your payroll system has checks and balances in place to comply. Audit your payroll system if required. Identify any potential red flags or risk areas. If you're concerned about compliance, then seek professional advice. Many employers discover non-compliance issues and need to look at remediation options, and even the Ministry of Business Innovation and Employment and the New Zealand Police, who are quite large employers, they've found themselves on the sort of thorny end of non-compliance issues, because some of the areas in the Holidays Act are a real sort of headache for employers to comply with based on how the legislation is designed. There may be some hope on the horizon coming as the government's hoping to, or there's been substantial work in recent years around streamlining and simplifying the legislation. But until such time as that happens, you'll see there that one of the bullet points talks to this issue. This is the law as it stands, and you need to do your best to comply with it. And many issues, as I've reiterated already, under the Holidays Act 2003 are complex and need to be assessed carefully on a case-by-case basis if you have problems or concerns regarding particular areas where there may be non-compliance. So employers assistance, as I mentioned before, we have an ebook on holidays and leave, which is quite a helpful resource. And we're here to sort of guide employers through the issues, but some of these more complex matters when you're talking about calculations and things may be work that's better reserved for a payroll consultant or an accountant or a hybrid of all three, professional advisors, lawyers, and also payroll practitioners to get a clear view on whether or not there are some compliance issues that need to be rectified and how you go about doing that. There is generally a 6-year limitation period for non-compliance under the Holidays Act and a corresponding or associated claim period, which pays to be aware of. Holidays Act, some thorny issues. So I'll just run through them quickly. Determining what an otherwise working day is in the context of public holiday entitlements, that can be a tricky issue where there is variability in how an employee works or a rostering system. What's an otherwise working day? How do we determine that? Do we look at a pattern over a preceding period like 3 months and get an overall gauge on the majority of days that they're working prior to the public holiday falling? What's the best way to ensure compliance here? Gross earnings for the purposes of holiday pay calculations, for example, average weekly earnings, what's included in that calculation or that definition and what's excluded. The law has some, factors and considerations there that need to be carefully assessed and inputted when it comes to calculating the holiday pay that is needed to be paid. Requiring an employee to take annual holidays with 14 days written notice. There is a requirement in the legislation that you need to reach agreement first in good faith. So you actually have to have a conversation and do your best to agree on options for an employee taking annual leave. But if they have a lot of annual leave and you do that, there is an option for you to require them to take the leave by giving notice. Sometimes that can be a bit of a contentious area. Section 16 of the Holidays Act, and that's continuous employment for annual holidays or the purpose of annual holidays. That also includes a situation where an employee is off on, medical leave or health leave due to an accident under ACC, the Accident Compensation Act 2001. Many employers aren't aware that that's still continuous employment. And to the contrary, employees still continue to accrue and subsequently become entitled to annual leave whilst they're off on leave due to medical reasons or medical incapacity. We have a separate ebook on ACC employer considerations that goes into quite a bit more depth around these issues. If that's applicable for you, you can check that out. Cashing up annual leave. So there's a rule in the Holidays Act that you can only cash up a maximum of 1 week annual leave entitlement per year, and that has to be at the employee's request. The employer has no unilateral right to cash up an employee's leave. It's by request and agreement, essentially. The relationship between annual holidays and public holidays. So, rules around public holidays that fall during an employee's annual holidays must still be treated as public holidays and not as annual holidays. So it doesn't reduce the amount of annual holidays that they have. Those public holidays must still be paid. The projection rule, as I call it, under that particular reference in the Holidays Act at section 40, this one applies where an employee has annual leave entitlement, so annual leave that has arisen after a year or more continuous employment. They have that available at termination, and what it says is you've got to count forward how much annual leave entitlement the employee has, although they have taken the leave immediately after termination. If any public holidays fall in that subsequent period, despite their employment ending, those public holidays must still be paid. Again, you can check that rule out under section 40 of the Holidays Act and at the reference in the slide there. Exchanging alternative holidays for payment or cashing up alternative holidays. There is a rule in the Holidays Act that can only occur after the alternative holidays are more than 12 months old. So there just something to be aware of around how pedantic the holidays can be on its prescriptive rules at certain points and issues. Employing casual staff and casual employment agreements. The key consideration here is if you're engaging casual staff, be very wary of the potential fish hooks or open knives that you could run into with this. So, casual needs to be casual is the short point. So that means how they're working and how you're engaging them. There's no regularity or pattern of work. The employee is free to decline the work, and they work on a truly ad hoc basis. You need to be careful as the employer is, whilst casual arrangements can start out as truly casual, they can often evolve and morph into more permanent employment relationships. And if that occurs, then by default, the law says that they become a permanent employee based on whatever their pattern of work is, whether that's a permanent part-timer or full-time employee. So it pays to be very wary of that. There can also be implications for failing to pay holiday pay correctly, namely accruing annual leave and paying it in the appropriate way versus paying 8% holiday pay as you go. If you get that wrong, the short point there to note is if you paid 8% holiday pay on a pay as you go basis, in circumstances you weren't, as the employer, legally able to do that, the employee can claim full payment of any annual leave that should have been paid. So effectively, double dip employers would say that they'll be doing, but that's what the law says, and that gets quite frequently upheld in decisions in the or determinations in the Employment Relations Authority and beyond, where employers get that wrong. So again, quite important to have a clear sort of overview and monitor casual employment relationships and the rules with them. Just generally some helpful links and resources. So our members or subscribers can access the Employers Toolbox, which is basically a online HR portal or library software suite where we have various tools, resources, templates, ebooks, the employment agreement builders, policy documents, etc. So all of those resources are at the touch of your fingertips if you're a member of our organisation. The Employment New Zealand website is also quite good for some general information to check out if you need some general information and aren't a member. New Zealand legislation too. So I mentioned that before. You can find the various acts that are applicable and the section numbers if you spend enough time looking for them at this legislation link. So that's legislation.gov.nz. Also checking out case law databases, which are freely available, and I've got the links there if you want to check those out. The Employment Relations Authority database and the Employment Courts judgment database, where you can find decisions of the court or determinations from the Employment Relations Authority, which is quite helpful if you want a bit more information or after a particular case. That concludes this presentation on minimum employment standards and Thorny Holidays Act issues. I hope you've enjoyed this presentation and got some useful insights or information out of it that you can take away and implement in your business. If you require any additional information, support or advice, feel free to phone us. Free phone 0800 15 8000. That's 0800 15 8000. And we can assist you with other inquiries or questions you might have across the area of employment law and HR compliance. Alternatively, check our website out at www.employers.co.nz for more information. Thanks very much for listening to this presentation. Enjoy the rest of your day.